Tevi Troy joins us. He's a former senior White House aide and Deputy Secretary of Health and Human Services. If anybody would know about the Affordable Care Act, it would be Dr. Troy joining us. Welcome to the program.
Thanks for having me.
Well, I appreciate it. You know, it's interesting as the discussions go on, it almost, I guess this is the way it's being reported, that there are partisan lines almost on the court itself. How are the justices looking at this? Are they looking at the constitutionality or whether it's a good idea?
Yeah, well, I think the justices, for the most part, say that they are looking at the constitutionality and that it's not a question of the policy. Certainly the conservative justices have that approach. There's been a stream of thought over the years that the liberal approach is a little more flexible, that the living constitution is their approach. But the conservative justices say it's not a question of the policy, it's a question of the constitutionality. And the individual mandate seems to be beyond the jurisprudence of what the Commerce Clause has allowed thus far.
It seems like, just based on what I know about the law, that it seems like if the individual mandate is cut out, that the rest of it's going to be there's going to be a lot of regulation and a bulkiness to it that without the heart of it. I don't know, how does it work?
Oh, I think it's pretty bulky and with a lot of regulation either way.
Yeah.
I think the funding mechanism is problematic, and I think the bulk of the pain comes on the insurers. If they don't have the individual mandate, they don't get all these additional customers, but they do have all these additional regulations. So
Yeah.
I think the law may not be able to sustain itself financially if the mandate goes away, but the rest of the law stays.
Yeah, it's almost, just as I was reading the description and some of the questioning, it's almost like they're saying that the car is constitutional, but it can't have an engine in it.
Yeah, well, I don't know. Maybe I'm not a car expert. Maybe the alternator goes or something.
Well, let's talk about what they're talking about today. Now, this is the discussion about whether the entire law can just be tossed out in case that other part is tossed out. How do they know? How do they hear the arguments today about this when they don't know what they're going to do about what happened yesterday?
Yeah, it's a good question. So if they sustain it, obviously the severability thing does not matter. So if they say, based on yesterday, that they're going to maintain the individual mandate, then they're not really going to look at severability. Although this afternoon's case on Medicaid, or this afternoon's argument on Medicaid, is another thing that could go to this question of severability. So if they rule the Medicaid expansion to be unconstitutional, then the severability question would come into play as well. And the reason is because the Congress, when they passed the law, they didn't include the standard severability clause, which I think was a big mistake.
Tell me about the Medicaid expansion. What is this, and why are the states, 26 of them, fighting against it?
Well, the states are uncomfortable with the Medicaid expansion because Medicaid is a huge expense on them. It's a shared responsibility between the federal government and the states, but the federal government is claiming to cover 32 million more Americans as a result of the Affordable Care Act. Half of them, 16 million, would be done through Medicaid, which is going to strain state budgets as well as the federal budget. And the states are saying that this expansion is beyond what we can handle, especially with the additional mandates that you are requiring for coverage.
All right, but where does the constitutionality of that enter into the picture?
It's a question. It's a federalism question of the interaction between how much imposition can the federal government put on states.
But is there precedence, though, that can be cited that, the federal government can tell the states to do this, and here are the precedents for it? Are there any?
Yeah, it's a really good question. There were a lot of people who were surprised that the court decided to take up this aspect of the case. A lot of people expected the mandate to be called into question at the court level, but the Medicaid thing is somewhat surprising for that reason that you say.
All right, as we wrap up the discussion today, I suppose over the next couple of months they're going to be deliberating about this. Does media, do opinionators out there, do people protesting in the streets for and against, do those kind of things have any effect on the justices?
Well, if you ask the justices, they will say no.
Yeah. What do you think, realistically, though?
Look, I think there are some justices who you know where they're going to vote before we start, right?
Mm-hmm.
So I think everybody knows that Ginsburg's going to support the mandate, for example. But some of the other justices are seen as swayable. So they used to say that the New York Times and Washington Post editorials of the morning of might determine how a Kennedy or in the past an O'Connor might vote. Some of the other justices, they don't really care about that stuff.
I guess I have the purest view of this. Shouldn't they all be swayable in the beginning? They're supposed to hear the case at the court level.
Well, yeah, and of course, and I think Justice Roberts is good at building coalitions and looking at the precedents. And sometimes the liberals and conservatives, even though they don't agree and come from different perspectives, some of them have the closest relationships. So Scalia and Ginsburg, for example, are supposed to be pretty close friends. So you can see these unusual coalitions develop.
All right, this is Tevi Troy, former senior White House aide and Deputy Secretary of Health and Human Services. Thanks so much for coming on. I appreciate it.
Thanks for having me.
All right, we'll talk to you again.